Hello, my name is Robert Ernenwein. I'm a criminal defense lawyer and I practice law with Michelle Mathis. We're lawyers together. Here in Torrance, California, we practice throughout Southern California, primarily in Los Angeles and Orange counties. And I wanted to talk today, Michelle, about an issue that's really come up quite often in our office, which is the issue of bail. Bail in California is set by a bail schedule, generally, in each county. And then if the defense and or the prosecutor wish to talk about bail more, there are certain factors that the court has to consider. And the basic four factors are the protection of the public. The other factor is the seriousness of the offense. The more serious the offense, the more likely the bail will be higher and less likely to reduce. If there's a prior record of the individual, and then whether or not the individual is likely to appear for his or her court appearances and for trial. Those are the normal factors. But we've had a curveball. And the curveball is the California Supreme Court now, under a case called Humphrey, says what?
It says that you have to have bail set at the financial ability to pay of the defendant. So the unique factor that goes into setting bail now is a background on what the defendant's ability to pay is. You can't set bail at an arbitrary amount or just as a bail schedule, because you could set it at $25,000 and that might be really easy for somebody else to post. And then another person, they can't come up with the money to post bail. And so what Humphreys has said is that you have to take into account the unique financial ability to pay of the defendant.
So how does that have practical application in our office with our clients?
When we make a bail motion, we file a written motion with the court and we get a background and history on each of our defendants. Each of our clients has unique factors regarding how many times they've been arrested. Maybe they're a first-time offender. Maybe this is a third or fourth arrest. Is it a violent offense? Do they have any violent offenses in their background and history? And then we put together a declaration that outlines what their ability to pay is. Now, it's not very intensive. We don't have to come up with bank accounts and deposits, and just a declaration that gives a general overall picture of what the defendant's ability to pay. Somebody who owns property is obviously going to be able to afford to pay more bail than somebody who doesn't have any sort of assets.
And then the court under Humphreys is required to take that into consideration. In other words,
Absolutely.
Can this person pay the bail bond premium to the bail agent? Does this person have the collateral necessary? Or is this person simply sitting in custody only because they're indigent or unable to pay?
Right. And there is definitely a trend against people who are indigent sitting in jail just because they can't pay.
We have clients that individually do not have significant assets or any assets at all. And their family members might, but the focus is on what?
Oh, well, in Humphreys, the focus is actually on the defendant. So in a lot of our particular clients, we do have family members that are often financial resources for the defendant. But Humphreys does not require those same types of connections to the defendant to post bail. So somebody who is paying somebody's attorney's fees is not required to pay their bail.
Right.
And that's the distinction, is that even if somebody else has paid their attorney's fees, the person can still qualify for a lower reduced bail or no bail based on Humphreys, because it's based on their own personal financial situation.
Practically speaking, how this takes shape in our office is if we are retained for you or for a loved one and the person is unable to reasonably make bail, we prepare and file a motion, we obtain a declaration, and we try to get that bail significantly reduced. But now, particularly under the Humphrey case, discussing and describing what that individual's ability to pay bail is and compelling the court to make those considerations. So if you or a loved one have a question about a situation where there's a bail issue in relation to a criminal issue, we're here to talk to you free of charge, no obligation. My cell phone, 310-892-3712. Feel free to call me. Michelle and I would be glad to consult with you. Thank you very much, Michelle.
Thanks, Robert.
And thank you.